Thanks everybody for attending. We'll make some introductory remarks and then get into the actual substance of the webinar. Again, I'm Chuck Krugel. I'm your moderator as always, and you're here for number 5 of the webinar series. It's number 5 of 7. I know what you did last summer, workplace investigations. This webinar is part of Financial Employees series, Protecting Your Employee Assets, the Life Cycle of the Employment Relationship, 2024. Slides 9 through 10 of the PowerPoint provide summaries of the series and this episode. Slide 6 is our typical disclaimer, reminding you that you can't go out and make important decisions based on what you learned in today's webinar. We're not your advisors or attorneys, and you're not our clients. The stuff presented in this webinar is meant to give you general knowledge, help you select and work with advisors of your own choosing. And speaking of the slides, understand that we will not be lecturing off the slides, nor will we go through the PowerPoint deck in order. So you don't really have to listen to us read slides. This webinar, like all Financial Employees webinars, is a discussion between the panel. More about Financial Employees, by the way, is on slide 48. We will refer to the PowerPoint at times, so you may want to keep it nearby. And our panelists today, as always, is Max Barrett, partner at the Garfinkel Law Group, Helen Block, the law office of Helen Block, and Amit Bindra, partner at the Prinz Law Firm. Again, if you want to find out more about us, you could check out slides 42 through 45, which contain our bios. If you're attending a live premiere of this webinar, you can submit questions using your web portal. If you're watching on demand and have questions, you could also submit your questions through info@financialemployees.com. Also, if you want to submit questions after the webinar, you could do that also through info@financialemployees.com. Thanks to our sponsors, as always, Mood Online Marijuana Dispensary, which is on slide 4. Type to Learn, which is a digital learning solution provided by Sunburst Digital, sunburstdigital.com. And also Max X Asset, a simpler, easier, and better way to conduct online asset sales. And they're also on slide number 5, along with Mood. So with all that being said, let's get into the actual substance of the webinar now. Helen, we'll start with you. Here's kind of a simple and fundamental question. Who should conduct investigations? The owners or operators of the business, or like a third party, like a HR consulting company?
As with most questions that you ask, Chuck, it depends is the answer.
Yeah.
And here's what I mean by that. It depends on the nature of the complaint. It depends on the level of severity of the kind of complaint. And I'll give you a few concrete examples. So if, let's say, for instance, there's a squabble between 2 coworkers, and one coworker, let's say, is complaining about the other coworker, that they're rude, they're disrespectful, they're, let's say, noisy, they're obnoxious, and they go, let's say, to the manager of the business to complain that this coworker is in violation of the bullying and harassment policy of the company. A complaint like that, I would say, you could probably handle in-house. It doesn't necessarily expose the company to liability, depending on how you're going to handle this investigation. Let me make that caveat. But assuming you handle the investigation and take this employee's, comments seriously and look into the situation and basically nip the problem in the bud, it's going to stay within the company, and it's more likely than not going to expose the company to liability. It doesn't involve necessarily a manager. It doesn't necessarily involve an owner of the company. So the potential exposure to liability is really, really low in that situation. And so it depends on the size of the company. If it's like a really small company where, let's say, there are 10 employees, the owner could handle the investigation themselves. If it's, let's say, a larger company that has an in-house HR department, then usually it's the HR individual who's going to investigate a situation like that. If you have, let's say, a situation, even if the owner of the business feels it's unfounded, but an employee alleges the owner of the business or a senior level manager of the business sexually harassed, for example, this employee, and there's potential exposure to liability, the allegations are very serious from a very, very credible employee, in that situation, you really might want to hire an outside investigator who does not have a connection to the business to give the appearance, especially that this investigation is going to be impartial. And it should be impartial, whether you use someone from the inside or use someone from the outside. That is the job of the investigator, is to investigate the facts and the circumstances of the situation. And in that situation, you really might want to use an investigator that is not a member of or is not on the payroll of the company, other than merely being contracted to perform this kind of an investigation. So those are some of the factors. I know I gave one real simple example that's not necessarily very serious, and I gave a much more serious example. And the various scenarios fall within the middle and every which way. And so those are generally my guidelines for when it should be conducted in-house as opposed to out-house.
So I have a question. I guess I can throw this to all of you. What about if you're using an attorney, like you hire an attorney to conduct investigation? What about attorney-client privilege? What is, in that context, what's the implications?
So I think you're getting to, I think what we've called the upjohn warning situation. And that really depends also. If you hire an attorney in their capacity as an attorney, it's one answer. If you're hiring an investigator who happens to be an attorney, but not in the capacity of an attorney, then that's a different situation, because that individual is still being hired as an investigator. It's not necessarily representing the company as an attorney. That individual should still give what's called an upjohn warning, which is that tells the individuals that, yes, even though I might have a license to practice law, I'm not your lawyer. There's no attorney-client privilege between us. So that way the employee doesn't feel as though they do have privileged conversations and this is a lawyer for them. So irrespective of whether a licensed attorney is wearing the hat of an investigator or the hat of an in-house counsel, that attorney should give that upjohn warning, especially to if they're being hired as an investigator, they definitely need to give that upjohn warning to whomever they speak with. But if, for instance, let's say you're using an in-house attorney to gather information, not necessarily conduct specifically an investigation, but to gather information, there could be some attorney-client privilege issues. There likely could be attorney-client privilege if, let's say, you're talking to management. So if, let's say, the attorney is investigating for litigation purposes, not necessarily to get to the bottom of the allegations, to see if, let's say, there should be a corrective action in the place of employment, but there is litigation, there's a threat of litigation, and the in-house attorney is, let's say, investigating for purposes of possibly litigation. There might be attorney-client privilege between that lawyer and, let's say, management, but unlikely between lower level employees. So they should definitely give that upjohn warning to the lower level employees that, look, I don't represent you. This is not subject to the attorney-client privilege, because they will have to disclose that conversation to management and to upper level individuals. And those conversations that might also become work product probably would be subject to the attorney-client privilege if handled right.
Great. Thanks, Helen. Moving on, Max, what constitutes an effective investigation? Are there like some simple sort of common denominator rules for these?
Yeah, it's funny because like this one of our webinars is the most sort of, there is an art, not a science to a lot of the answers.
Yeah.
I think a lot of our webinars, we're all saying different variations of similar things. Document well, follow these ironclad rules. Some of us, based on our practice area or our focus within employment law, may lean more heavily into one area or another. This is one where I think a lot of different good practitioners can have very different answers to that same question. Because it is an art, not a science. That said, I think there are some basic principles folks should follow. First, if you get a complaint, even if it's Helen said, like it's an employee who's a complainer who complains about everything, who to be, dramatic or what have you, take it seriously. Because one of the first bosses I worked for as an attorney I respect a lot, I remember looking at some notes one time in a hostile work environment case, and I said to him, such and such, so I think there's a claim here, but also some of this stuff is kind of bizarre. She seems a little bit off base. And he goes, yeah, no, I think you're right. Some of this stuff's a little goofy, but some of it really did happen. And hey, crazy people can get harassed too. So, you just never know. Even people who cry wolf a lot, sometimes the wolf does show up and there is really something going on there. So I think the first thing is take it seriously, read it, and identify, what are you looking at here? What kind of a complaint is this? Is this a harassment or discrimination complaint? Is this a one-off incident? Is it ongoing? Is something criminal implicated here where we need to think about getting our lawyers and then law enforcement involved? So I think the first step is look at it, take it seriously, consider what you're looking at, and then decide, whether you have an internal decision tree or you have some flexibility, what direction do we need to go from here? I think having an idea and mapping out what the investigation should look like, who are the parties involved, who has knowledge, who needs to be protected as we investigate this. These are all things you need to think about. You also need to think about who is the proper investigator here. Helen talked about, should it be the owner of the company? Should it be a manager? If you're lucky enough to be big enough to have an HR department or a in-house counsel who's capable of doing some sort of investigation, probably good to have that person do it, unless the complaint is about them, in which case, if someone is the subject of the complaint, they really ought not do that. Or there are privilege concerns down the road that you think, what, if our lawyer gets involved at this stage, we need to consult with them, but that person can't do the investigation because they may need to be involved in an advocacy or defense role down the road. I think, in terms of the different reasons for it, whether it's a pay issue, somebody saying I didn't get paid correctly, or some illegal pay practices going on, or it's harassment or discrimination, you want to think about who are the witnesses and who do we need to speak to. And I think to the extent you can start to preserve confidentiality when possible, it's a good idea. But like Helen, I think also said, there's no such thing as immunity. Sometimes I like to invoke the TV show The Office when I talk to clients, more in a don't let this happen to you and this isn't how any of this is supposed to work kind of way, at least as to the deposition episode. But there's an episode where they have an HR seminar and Steve Carell's character, Michael Scott, as he's wont to do, thinks the presentation is boring and decides to go off script, which is always a great idea, and says there's total immunity and gets people to start confessing bad things they've done to the company. And it gets out of hand. And as the HR rep points out, there's no such thing as immunity in the workplace. Confidentiality and immunity are not a thing. So when you're doing the investigation, people need to understand we're going to protect you from retaliation, whether or not something comes of this. But we can't promise it's going to stay confidential. And I know some of these are topics that we're going to touch on a little bit later as well. You want to think about whether or not you need to document the investigation. Usually I'm going to say you're going to want some kind of an investigation documentation to confirm that you did look into it, what you did to look into it, and you either confirmed, denied, or couldn't corroborate certain things. And if necessary, what steps you took to remediate the problem. Because again, you always want to think about these things in the cold, hard light of, what is this going to look like in the cold, hard light of a disciplinary hearing or an investigation by the government or a lawsuit? How is it going to look on the back end as to how we handled it? I think you want to be timely about it. Items in the budget that don't show you in the black, they're sort of red line items. And by that, I mean, you will never generate profit from these investigations, but you can mitigate long-term damage. So take them seriously and prioritize them as is necessary. Don't wait until it's too late to do something. If somebody's been complaining about harassment, and I always go back to that because that's where a lot of my practice is oriented, and you wait until the third or fourth complaint about a supervisor being inappropriate, you've probably waited too long by then. You also want to make sure you choose the right investigator and don't pick somebody who's got a vested interest in the outcome being a certain way, or who would have a bias, or maybe is the accused perpetrator of whatever the conduct is themselves. And again, and I'm just going to repeat this, do not guarantee any kind of immunity or confidentiality. I think you can, if you think someone's involved but is a lesser player in something, you can always think about punishing less harshly for honesty. But like at the end of the day, you need to get to the bottom of it. You need an accurate record, and you can't make promises you can't keep. Because if this investigation comes in a, like if it comes out in an EEOC investigation or in a lawsuit, if you've kept names confidential, there's going to be credibility issues as to the validity of the investigation.
Thanks, Max. So kind of continuing on in this vein, should different protocols be used for different types of issues? What sort of protocols or why?
Well, to mimic Max and Helen's answer, to some degree you have to, because not every investigation is the same. So there's not going to be a one size fits all approach to this. There are good practices you want to follow in the sense of you basically what Max and Helen said. You want to make sure you know the right person who's doing the interview, you're conducting the interview properly, you're considering all those factors. But in terms of how it's done, it's going to change depending upon the type of situation, the type of claim, who the complaint is even about. So, for example, Max mentioned this. The complaint's about, let's say, your general counsel. That general counsel should not be the one conducting the investigation. So your protocols are going to have to be somewhat flexible based upon what the complaint is, the legal claim within it, and who the alleged perpetrator is. But that doesn't necessarily mean you shouldn't have a general blueprint of how you want to conduct these investigations.
Well, and I think the benefit of having at least a framework for how these things are supposed to go is then down the road, if there are questions about its viability or whether you gave somebody special or worse treatment, you can say, look, we don't have a one size fits all. If it's a whistleblower case versus something else, we treat it differently, but we followed our standard operating procedure as to what the steps were, even if the steps themselves are different. Like, it is nice to have some mechanism that's lined up for that reason.
Yeah,
Right, so
exactly.
for instance, sorry.
Oh, sorry, Helen.
I was going to say, depending on the type of allegations and where they took place, a proper investigator might need to even go to the location where it had taken place and see if the actual setup, etc., makes sense based on what the individuals complained about. So, or even if, let's say, third parties may have observed, they might be witnesses. So, for instance, I remember one time I was representing a business and there were some very serious allegations that took place at a holiday party. Often holiday parties do not happen at the premises. And so in this situation, it's important for our investigator to actually go to the location where the holiday party happened. And we were able to get a lot of good information that helped us determine what happened in this situation by speaking to the folks who worked at the restaurant that evening. And they actually very clearly remembered a lot of the situation that had taken place, which is why one needs to be flexible in their investigation and not follow a very, very specific roadmap. The roadmap that you're going to follow in general is you're going to need to speak with the alleged victim. You're going to need to speak with the alleged harasser. You're going to have to speak with various witnesses that both sides mentioned. You're going to have to get documents and information. But after that, it's very individualized depending on what those documents and information show and what the allegations are.
And to that point too, when the complaint is made, is it a lawsuit? Is it an internal investigation? Is it something else? That all changes the dynamics as well.
Well, and also, like, I had one where it wasn't, I mean, we'd sent a demand letter on a case, but it was a guy who got injured on the job, had a workers' comp claim and got fired. In retrospect, now we know it was because there were some communication breakdowns. But we'd made a settlement demand and the company didn't want to do anything until they knew what happened, because they were a company that was genuinely very concerned about safety and not having repeat incidents. They didn't want OSHA up their butts and they wanted to actually make sure people didn't get injured. So what we ended up doing was a site visit where opposing counsel, myself, my client, and like the plant manager walked through and basically recreated what had happened that day just so they could determine what went down. Sometimes it's stuff like that. It's like off the beaten path, but it had a lot of value because the company was able to figure out they didn't have an ongoing risk, or they did. I don't remember the specifics. Everybody was kind of able to walk things back. The client got, some face saving opportunities there, and everybody, felt better about it. So, I mean, it always looks different. And I think, you can send the message to your employees too, even if nothing comes of it, that you take it seriously and you do a robust job on it. People like knowing that the employer cares. I mean, if it's a harassment or retaliation situation, which I know we're going to get into, there may be no placating everybody. But if there are ongoing safety issues or just like recurrent issues, and you have a record of taking it seriously, you're going to have a happier workforce that knows that you care about what they're complaining about too.
Is there any like statute of limitations on conducting investigations? Like if an issue comes to your attention, a harassment issue, and it's like a few years old?
So I think Max gave a great example of a situation where just because a statute of limitation on a claim might be up doesn't mean you may not want to investigate it. Like, let's say it's a safety issue. It could be an ongoing issue. So there could be another employee who raises the same issue. And a company may just want to demonstrate to employees they look into this stuff. If you have an harassment situation that creates other issues, if it's wage and hour, that could even if the statute of limitations on the original complaint is up, maybe that issue is still ongoing for other employees. So yes and no, I guess. Once the complaint is made, I think you have to make a determination of how quickly you're going to actually look into it. But just because a complaint might be years old or outside whatever window there is from a legality standpoint for that specific issue, I don't think that means you necessarily don't want to look into it as a company.
Great, thanks. So moving on, Helen, at times I've heard of references to Farragher-Ellerth defenses, and that's in our PowerPoint slide number 16. What is this defense?
So Farragher-Ellerth referred to two actual Supreme Court cases that came out the year that I graduated law school. Yay, 1998. And one is Farragher versus City of Boca Raton. The other is Burlington Industries Inc. versus Ellerth. And so because these two cases came out on the same day by the Supreme Court and had similar principles that the Supreme Court held, they became known as a Farragher-Ellerth defense. And so basically what that means is that a company, if they have proper policies and procedures in place, let's say they have a handbook that talks about how you report sexual harassment, how you report discrimination, and employees don't avail themselves to those aspects that are implemented in the workplace, those things that could help them, then the employer is able to say, hey, we didn't know about it. If we would have known about it, we could have done something about it. And therefore, we should not be held liable, let's say, for hostile work environment or sexual harassment, because we would have nipped it in the bud. But because the person didn't tell us and didn't follow our policies and procedures, we should not be held liable. And that's why it's important for employees to tell folks to read their handbook and to see how to report discrimination, harassment, hostile work environment, et cetera, so the company has an opportunity to investigate and take action. So basically, if you haven't given the company an opportunity to be on notice, then the company might be able to say, hey, we shouldn't be held liable. Now, that defense is only good if the company has those protocols in place. If the company does not have those protocols in place, then they're not going to be able to raise a Farragher-Ellerth defense. Then they could perhaps be held strictly liable if, for instance, it's a supervisor who is the harasser. Then the company will presumably be on notice of this inappropriate conduct if, let's say, they don't have a mechanism to report. They don't have a sexual harassment policy in place. They don't have a handbook that explains to employees where to go, what to do, and how to handle a situation if you do feel that you are being subject to harassment in the workplace.
So you brought up a term, strictly liable or legally strict liability. Can you briefly explain what that is?
Yeah, so that's a principle that isn't necessarily just in the workplace context. It's in many, many contexts that it comes out. It's like a legal term that basically says an entity can be held responsible, like no matter what, for a law violation. It doesn't make a difference if they have a good defense or not. So for example, an example that everyone can, I think, appreciate is driving, right? If you, let's say, if you speed, for example, and the cop gets you, but doesn't get someone else, and you say, hey, but everyone else was speeding. Well, you admitted that you violated the law and you could be held strictly liable for violating the law. So it's not just in the employment context. When I use that term in the employment context, it often arises in the situation where an employer can be held as engaging in wrongful conduct if, let's say, its agent, meaning the supervisor, if they truly are an agent of the company, if they're engaging in wrongful conduct, and that wrongful conduct can impute to the employer, and that employer will be held liable, even if the employer can say, hey, I did not know about it. So strictly liable means in certain situations you can't have that liability, even if you feel you didn't do anything wrong or you have a good defense as to why this inappropriate conduct took place.
Thanks, Helen. So moving on, Max, when do you involve law enforcement investigations? Like, what are some of the scenarios and, timeline wise, when should you involve them? And if you involve them also, I mean, should an in-house investigation still be conducted?
So there's no comprehensive list, right?
Yeah.
There are a lot of different situations. I think a good baseline rule is think back to the answer of what makes a good investigation, to the extent you think that answer was good, and go to the beginning of identify the problem. Like, what kind of complaint are you getting right now? Look at it quickly and determine, like, is this a legitimate like, what is this complaint basically, and is there a potential that something illegal is going on? I think you want to get your attorneys involved quickly, but not long after that, you're going to need to call law enforcement. And I mean, you may not have a chance to do that, depending on the severity and the acute nature of the situation. You get a call from the warehouse in a manufacturing or in a blue collar setting, and you hear like a report that something violent is happening or there's a danger. You can't stop and think, should I call my attorneys? You need to call the police, because there's an ongoing danger to your workforce in that moment. Now, that may be a very extreme example, but whenever you think there's a possibility of some immediate danger like that, you probably ought to call 911. Stepping back, if it's not an immediate issue like that, but it's an ongoing issue where you do think law enforcement will need to be contacted, I think the common example that comes to mind is like an employee who's embezzling, for example, or doing something improper with company funds. Like, you should call law enforcement. You might need to do some of your own investigation first to unravel what you've got, so you can explain to them with some credibility, here's what is happening. Is that going to get you your money back? No. And your lawyer is also not ethically permitted to leverage getting the company paid back against that person's prosecution. But at the same time, you're going to want a criminal record of all of this. You may want that person investigated for a lot of different reasons like that. So I think, the long answer to the short question is early, if it's necessary, and if you identify a potential issue that requires law enforcement involvement. And by the way, that may not just be, the local police or what have you. God forbid, there can be a lot more serious issues you might identify that involve use of computers, some kind of ongoing fraud. If you're a financial institution, financial regulatory laws. I saw in the PowerPoint a few minutes ago, Sarbanes-Oxley came across the screen. So there are different regulatory requirements that your industry or your business may have. And so I think the other rule of thumb to keep in mind to that effect is, what industry are you in, and do you have mandated reporting requirements when you uncover certain conduct along the way? I think the last part of the question, should you still conduct your own investigation? Yeah, you should, because law enforcement does not always complete it. They may be looking for certain items. I know of a case recently where there was some unlawful recording done in the workplace, something really inappropriate that was done with a camera in a bathroom. And law enforcement got a hold of the phone that the camera was connected to. But to my understanding, they did not bottom out the issue of everything that was there. They stopped pretty much when they felt they had enough to charge and convict. And you may have further exposure. You may want to look into certain items as a company that may go beyond what the local police or whatever an agency is willing to do. It's probably going to depend on whether it's a state or federal law enforcement agency involved. State agencies are a lot less resourced. The feds, nobody ever seems to get away from the federal government if they want to go after you for something. So, the resource allocation is going to be different. But, if there's potential illegal conduct, you can't bury your head in the sand and pretend that law enforcement won't find out. And to the contrary, if you try to cover this sort of thing up, it's always going to get way worse.
When law enforcement may not want to look into something, but that doesn't necessarily mean the company shouldn't. So those are sometimes two different tracks. And so I think for that reason too, companies need to be careful.
Yeah, I don't want to get specific, but I know that some law enforcement agencies just don't want to conduct a thorough investigation from A to Z, or they don't have that level of sophistication.
Or they don't want to tank their stats or anything, right? Like, well, that's our work issue. Why are you calling us? It's like, well, because they committed a crime against the business, or against a person here.
You give you the response like, look, we got, all these violent crimes going on, and we just don't have the means of, investigating this type of crime.
Right. But, like, especially if you're like the CEO and somebody comes to you with a whistleblower allegation, your first call needs to be to the general counsel. And then after you've talked to them, your second call probably does potentially need to be up the chain or to law enforcement at some point in time. You can't say, let's protect the shield and close ranks here. That can't be the reaction.
Sure. Well, thanks, Max. Amit, moving on now with the subject of documentation. One of the big hallmarks of HR management or HR practices. What about documenting the witness statements during interviews? And what do you recommend as far as, statements, notes, or even like certifying or verifying witness statements?
Well, I kind of want to start at the end of the process, which is you're likely going to have a final report. And so within that report, you're going to have a summary of issues, facts, methodology, the scope, etc., your findings and recommendations. So in order to have a good report, you also then need to have good notes. Otherwise, it's just not going to be as productive. And so I think because of that, you would want to be able to make sure you keep good interview notes yourself. If you can get written statements from witnesses, that's ideal because people's memories can change. And if they're sworn statements, that makes it a little bit harder to deviate later. To some degree, this is going to also depend upon what type of investigation it is or what triggered the situation. If it's in litigation, you may have a different thought process on how you want to handle it versus pre-litigation. So I think some of those factors may influence some of these things. But at the same time, your ultimate goal is to be able to make a report and make a recommendation. So based upon that, you do want to have good notes and good documentation.
Does doing anything like getting notarization or certification help for an investigation?
I don't know if a notarization really is going to move the needle that much relative to just a sworn statement. I mean, in court, for example, you can sign an affidavit that just says under penalties of perjury, this is sufficient based on if you're in state or federal law. That's probably sufficient for this purpose too. If you want to go the extra step of a notary, you can, but I don't know if it's really necessary.
Plus, if you have a witness to the conversation who can corroborate like what was said, or you are making your report typing up what the investigative sentence, what the statement was gained in the course of the investigation, like you're going to have a third party who can verify the substance of it. So,
there's actually a regulatory agency, a state agency I once dealt with that required all statements to be signed in blue ink, and they wouldn't accept them otherwise. And I asked the investigator once, and he's like, that's just what the law is. And, it's something we've always done. Some crazy stuff like that. Helen, what do you suggest regarding like the scheduling of interviews, preparation of them, and, some of the logistical issues that you've encountered?
So, of course, it depends on the type of investigation and the subject matter of the investigation. So for instance, if your staff is remote and they're not working in the office and you have to be able to have a conversation with someone who is working remote. And these are the kind of conversations you do want to have face-to-face, or at least if your staff is remote, to have it, let's say on Zoom, so that you can see the facial expressions. You can assess credibility as an investigator, because oftentimes investigators, like even outside investigators, part of their role is to look at all of the information that came in, the statements, who they talked to, and assess who's credible and who's not credible. And it's too hard to do that on a phone. It's too hard to do that by email. So it should be something face to face. It should be something, I would say, preferably in person, but at least like a Zoom kind of a format. Yeah. Oftentimes you want to speak to the person who complained first for many reasons. One, they want to know that something's being done and their complaint is being taken seriously. So you definitely want to start with the person who made the complaint, or more likely than not, you want to start with that person. The only time where, let's say, maybe you can't start with that person is if, for instance, they filed some kind of a formal complaint. You have the gist of their complaint in writing and they're just not available. Let's say they're on vacation or who knows what. Then you might have enough of a basis to start your investigation without the alleged complainer or victim. So as a general rule of thumb, I would say start with the alleged complainer or victim, unless that's just not feasible. And then generally I say find out who the witnesses are and then talk to the witnesses. The gut of some people is to, let's say, talk to the alleged harasser next after the victim. But me personally, I rather talk to some of the witnesses to get more of an idea about the person who is the alleged harasser before I actually speak with the alleged harasser. So to me, personally, I like to gather as much information as I can when I speak to the alleged harasser. So this way I know something about the situation. And if the alleged harasser makes certain comments, especially if, let's say, by that point, I realize they don't sound necessarily so credible, I have some other additional background information to be able to ask further questions to assess the credibility of the alleged harasser. And sorry, Chuck, you were about to say something and I kept talking.
No, that's cool. So Max, you delved into this one topic but earlier, but let's focus more specifically now on confidentiality. I mean, there's really no such thing as absolute confidentiality, but what can you do to ensure that confidentiality is maintained and that people feel comfortable about divulging, sensitive information?
Amit's giggling.
Turn yourself on mute.
Because I got the mute wrong. Because on our podcast, we at least once a show always do that.
I was definitely giggling. It was great.
Good to know it's a recurrent issue no matter where I am. So I think some of what Helen just touched on, verges into this as well. I think some of it has to do with how you go about conducting the investigation, right? Like if it's a harassment, I go to harassment a lot because I think they're good cases to use as examples for these investigations because they're very fact intensive. They involve a lot of subjective opinions and what other people and your alleged perpetrator and victim or witness or survivor have seen. And so I just think they make for good test cases for what an investigation is. So that's why I go back to it a lot. But thinking of a harassment setting, especially if there's a supervisor involved, I think the thing I would not do as a point of contrast is like march into the plant or the office or wherever this is going on, make an announcement, grab your first witness and yank them to the back and, in broad daylight. Like you want to use discretion. You want to think hard about how can I do this in a way that maybe I can't promise confidentiality forever, but I can avoid drawing attention to the fact that this is happening. I can do it when the potential perpetrator is not present, when they will not be able to see what's happening, where I can do it in a way where they're not going to be able to, neither they nor the complainer are going to be able to influence the witnesses. So I think thinking about ways to go about talking to witnesses that way is helpful because maybe you can't guarantee forever confidentiality, but you can avoid drawing attention to their participation. I think you can also you can't promise all confidentiality, but you can say, look, we're not going to draw attention to this. Tell them it won't be confidential, but that you're not going to, until the investigation's complete at least, and you come to some resolution, it's not going to be publicly broadcast. Potentially the people involved may find out that you spoke about it, but that you assure them there will be no retaliation. And you might even tell them what steps you're going to take or, direct them to certain policies if they exist, and they should. That protect them from that sort of thing and reiterate to them that there's an open door policy or whatever mechanism you have that if they start to feel like either the complaining witness or complainer or whatever we say and the perpetrator or alleged perpetrator, start to put heat on them for what they did or didn't say in the investigation, that they have the ability to come back to you and, report that right away and that they should do that. So, I think the way you do it is basically assure them that no harm will come to them for telling the truth, unless they did something improper and they get themselves into trouble too, obviously. But I think those would be the idea is, assure them of their protection for telling the truth, assuming they didn't break a rule, avoid drawing the attention to it, and to the extent possible, avoid broadcasting it. And look, like you don't tell just because it may come out in a lawsuit or in a report in an administrative agency, doesn't mean that you're going to go around the whole office telling everybody what somebody saw or experienced. You'll still keep it confidential to the full extent possible. It just won't be completely confidential forever.
Well, Max makes a really good point because you should tell whoever with whomever you're speaking, you should let them know. And usually you see this in handbooks also that it will be kept as confidential as possible. You also want to caution folks, especially the witnesses, that they should not be discussing this with other people, that they should keep it as confidential as possible. This is going to be kept as confidential as possible and to not discuss it. Because you do want to try to keep it confidential to the greatest extent possible. So you don't want the people with whom you spoke, especially to coach other individuals either. This is what I told them. And you don't want all of a sudden people to come up with the same story either. So you do want to tell the people with whom you're you're interviewing as part of the investigation, that you do want them to keep their conversation confidential and not to discuss with others the conversation that they have with the investigator.
Thanks, Helen. Thanks, Max. Amit, moving on with and keeping our focus on documents and records, what are the types of documents or other sources of information that an investigator should ask for prior to actually starting the investigation and during it?
You would want to ask, I think, for some of the stuff really that's on the slide, the personnel file, other complaints. You may want to look through emails, documents, correspondence as much as you can. If you have access to text messages, that'd be ideal, but that becomes tricky. You also want to double check your own policies. So they might be in your handbook or they might be contained someplace else, but you want to look at those too, insofar as those might be implicated. And then separately too, if you're a unionized company or facility, you want to double check the CBA and figure out or make sure that you're complying with the CBA requirements and any union requirements that might exist for any such investigation. There are other places to potentially look for information, but those are going to be trickier. So text messages I mentioned, voicemails, telephone records are a little bit harder potentially to do in an early investigation. Some of this may require getting a subpoena. If you can have access to a video, that's great. Max mentioned an example in which there was, a video on a phone, if you can do that. Sometimes depending on the investigation, maybe social networks, some stuff might be publicly available on Facebook or LinkedIn, Instagram. So if it's a harassment type claim, something like that, those are publicly available. You may want to gather that information as well. So I guess the short version of all of this is the stuff that's going to be relevant to the type of claim you're looking into. If it's wage and hour, you might want to look at clock in, clock out type stuff. If it's harassment, if there is written communication, those are things you're going to want to ask for.
Kind of, I guess, looking at the broader picture, I mean, how do you know if this type of information exists, like voicemails, text messages, the social media postings?
Asking is helpful. I mean, when you're doing the interview, you want to ask the witnesses, especially the person who's making the complaint and depending on the type of complaint, I think that can also influence what questions you're going to ask. But you can ask them, if it's a harassment claim where someone is engaging in alleged sexual harassment, maybe you'd want to ask, are there text messages? Are there social media messages? Stuff like that, because they probably do have a copy of that. Those may be referenced within the complaint itself. So a lot of it's going to depend on the type of investigation. If you are concerned that an employee is stealing confidential proprietary information, you may want to look through their company emails to see, are they emailing stuff to themselves? And that's pretty easy to do because you could just search their inbox or sent box for their personal email address and see what's been sent out, or just Yahoo accounts or AOL or whatever people are using. So those are all different ways to be able to ask for that type of stuff. And you want to be creative. To some degree, you want to ask some open-ended questions in the context of the sources of information too, just to get a better sense of what may be out there.
But I think you also know your own workplace, right? Like you understand, I mean, if you're connected to the employees and sort of the work culture and how things are done, you'll probably have an idea of, maybe not you per se, but the employer will, like, how do people typically go about doing things? Like, what are some common things that maybe employees don't realize the employer knows, but that maybe they let slide, or you kind of know go on. You know how long you retain security footage and emails for. If Slack chat or some other internal mechanism exists for communication, and if people have a habit of doing certain things with those softwares and those pieces of information that either are or are not kosher as far as your workplace is concerned, and what the policies are. So, I mean, also think about all of that, because that'll also guide what you're doing there.
Thanks, Max. And thanks, Amit, too. So, Helen, once we finish the investigation, how should it be wrapped up? What kind of reports should be generated? How do you communicate findings and conclusions? That type of stuff.
The investigator should look over their notes, summarize their notes in an investigative report, and based on their analysis of their investigation, they should give sort of a conclusion as to they did think something happened, they didn't think something happened, and suggestions as potentially for next steps. So, for example, let's say they found that using Max's example of sexual harassment, let's say someone complained about sexual harassment, and the investigator at the end of the investigation basically concludes it didn't rise to the level of sexual harassment. This wasn't sexual harassment, but this individual who was complained about was kind of an obnoxious person, used perhaps some inappropriate language. I just don't think it rises to the level of sexual harassment. The employer then can look at this and say, okay, fine. We've covered our bases. This is what we've done. But maybe we should train this employee on how to act better in the workplace so we don't have another problem again, or we don't have a problem that gets worse, because there is a problem. So even if, let's say, something is not necessarily legally liable, so the employer might not be liable for sexual harassment, it still shows that there's something wrong in the workplace. And in terms of your workplace culture, you probably want to do something about it and not just brush it on the rug and say, oh, phew, thank God it wasn't sexual harassment. Let's go on. Nothing's wrong. So you want to take the investigative report. You want to have an investigative report. You want to have an investigative file that's separate and distinct from the various individuals' personnel records. And then you want to talk to the alleged harasser. You want to talk to the victim or the person who filed the complaint. Explain the findings and then take any corrective action that may need to be taken. You might give even, let's say, a written report to each and put that as in a report, meaning that you give to the individual, like let's say a memo or something, that memo might be put in the personnel file of each respective individual, especially if there's going to be some discipline. So for instance, let's say in my sexual harassment example, you go to the, alleged perpetrator and say, hey, it turns out that we believe that you use some inappropriate language. We counsel you to not use such language in the workplace, and don't do it again. And stick that memo in the individuals as part of their personnel records so that there is a record of the fact that the individual was disciplined for perhaps engaging in some sort of inappropriate conduct. You would then meet with the victim and say, hey, look, we conducted a very thorough investigation. As you know, we had an investigator with whom you spoke. We did not find there to be sexual harassment, but we do find that there was some inappropriate language that was used. We don't tolerate such inappropriate language, and we've counseled the harasser that this is inappropriate. We don't, this is not the kind of workplace that we have, and this is what we found. And you might even want to give like a little summary in writing to that individual, and then you want to remind the person who complained and also the alleged harasser too that the company doesn't tolerate retaliation. They have a no retaliation policy. And there certainly is not going to be retaliation for good faith. That's the key, not any complaint, but good faith reports or complaints. And then if they do feel that there is any retaliation that has taken place, to come forth and to make a report. And so that's essentially how one would wrap up such an investigation.
Thanks, Helen. Max, what right do witnesses have in investigations? Can they refuse to cooperate? Can you spell out some techniques for protecting witnesses from supervisors or coworkers looking to retaliate against them or to like probe what they know?
Yeah, and I think as usual, I went beyond an earlier answer and probably stole way too much of my material from this one. But yeah, I think some of it is just common sense, right? Like the harassment examples I gave, or even whistleblowing. Like when you approach a witness, again, admonish them. You can't give them forever confidentiality or immunity, but you'll give them confidentiality to the full extent possible. Remind them of the anti-retaliation provisions, encourage them to come to you if they perceive any immediate or soon after change in their work setting where it feels like things have gotten worse or somebody has started to engage in a way that they feel is punitive or retaliatory. And, then use common sense and try to use your discretion where possible about how you go about questioning them, right? Don't do it right in front of the supervisor. Don't invite the supervisor, if it's a supervisor or a coworker, whoever. Don't invite that person to the investigatory discussion. Don't conduct that conversation in a way where the subject of the investigation is going to be tipped off by that conversation. Try to do it in a time and place where as little attention is drawn as possible. Try not to reveal that it's happening in real time. And if at the conclusion, depending on what the results are, there's no need to disclose that information, then you can keep it confidential internally. I think it's a question of like what comes of it after the fact. So those are different, strategies to apply. Practically speaking, you're in a workplace, so you give up certain rights. I mean, even as an employment lawyer on the plaintiff side, I'm saying this, like you don't have unlimited rights in the workplace. This isn't the right to remain silent in a criminal setting. You don't have that constitutional right at work. For most people, you're an at-will employee and you have an obligation to follow instructions, and that may include participating in an investigation. They can't say, I'm not going to cooperate. Now, there may be union and collective bargaining rights at play in a given workplace that may affect that, where they have a right to have a witness or a union steward or some type of person present to protect them or be a third party there for their benefit, just to confirm that certain things were discussed or not. So be mindful of all of that. And if you have a policy internally that permits that, don't deviate because you don't want to in a given setting, unless the investigation really calls for it, So I think, their rights, I mean, they have the same employment rights they've got in any other setting. If the investigation is retaliatory or what have you, they can treat it that way, but they can't just be insubordinate and say, I'm not doing it. And in fact, I think it's probably something all the plaintiffs' lawyers on this, or at least partial plaintiffs' lawyers on this call have seen before, where you've got a harassment or discrimination plaintiff who you're representing who still works somewhere, and the management side, the employer wants to question that employee. They don't have the right to have you there. You can't stop them from conducting an investigation. And in fact, if they obstruct it and they don't cooperate, that would be something you could use against them as a defense as the employer. So you shouldn't approach it with like a closed mind of, I'm going to use this to get the person that did this. But if people are not going to cooperate in the investigation, they're basically handcuffing you, and there are other legal consequences to that.
Thanks, Max. So, Amit, we've discussed retaliation to some extent. What is it exactly? I know, I get what it is relative to hiring and firing, but what about in investigations?
Yeah, and I guess I'm going to have to give a lawyerly answer of it depends. I should think an answer Helen gave earlier too. Depending on the law that's applicable to the claim at issue, the retaliation could be narrower or broader. And what I mean by that is an adverse action under one law may be broader under a different law. So I'm trying to pull up the slide where we have all the various laws listed. So under OSHA versus Title VII, an adverse action might be defined differently. An adverse action or retaliation could be, like you said, hiring and firing, but it also could be a change in pay compensation. It could be some sort of change in scheduling depending on the legal issue. Under some laws, it might just be, is it deterring someone from making a complaint? And so I think companies need to be very cautious about ensuring that if someone is making a report and it's being investigated, that their workplace conditions aren't changing because of that complaint, because that could lead to some form of secondary complaint or legal issues separate and apart from the original complaint that employee may have made.
Great, Amit. Thanks. So we got a few minutes. What about one of the things that Max, you triggered in my mind, Max, was what if an employee who's under investigation or a witness sends encrypted messages? They either sent or received the messages. During the investigation, and this is for everybody, can we ask for unencrypted versions of that? Maybe I want to handle that.
Do you mean in the context of a text message?
Well, in any sort of message, whether it's encryption can be, I think, done for a lot of digital messages nowadays. Maybe even voice messages, or that might come up soon. I mean, can we get beyond that, wall of protection?
Well, you can ask for it. I don't.
Yeah, I think it becomes tricky. You can ask the employee for it, but you don't have the same level of subpoena power that you would in a courtroom. So you're not in discovery. There's no court or judge requiring you to turn stuff over. So it depends on how much the employee wants to cooperate. To Max's point from earlier, there is some ebb and flow to this. You don't want to be obstructionist on the employee side, but then there's going to be an intersection of privacy laws too, or just privacy rights that employees are going to feel. So I think on both ends, you can ask for it, but there's no guarantee you're going to get it.
Sorry.
Go on, Helen, please.
What I was just about to say is that, you want to make sure you're not violating. There are a lot of different laws that can be in place. So, for instance, I would mention privacy, for example. So you cannot, for example, ask an employee to, let's say, give you their private passwords to, let's say, their Gmail account or their Hotmail account so that you could search yourself to see if there is documentation that bears on your investigation. To Max's point, if the witness is an employee, they need to cooperate. Otherwise, they would be insubordinate. So you could ask the employee and you could say, hey, I understand that you guys talked about a text stream on such and such a date and such a time. Please give me a copy of that text stream. And the employee, I would say, should probably give over a copy. Now, they could say, we have some private information in there. It's personal. It's private. It's my private communication. You say, okay, fine. Redact the private stuff. Give me the stuff that has to do with, that's relevant to this investigation. And then it becomes a really kind of a delicate line, because if the person flat out refuses, are they truly being insubordinate, or are they truly resting on rights they might have to their privacy? And you have to make, you might have to make a decision right there and figure out what it is.
And two other factors to consider there too are going to be A, are they using a company device for like text messages or whatnot? And B,
right, then there's no expectation of privacy.
Right. And then B, what jurisdiction are you in? Because I think some jurisdictions treat these things a little bit differently. So you may have to look into that aspect of it as well.
So, and this is kind of a difficult question, or tricky. So, Max, you discussed the idea that it's science versus art in terms of investigations. I agree that it's more of an art than it is a science. But I know there's a lot of like third-party HR providers out there who have like templates and rely on systems and all that. I mean, if a provider or somebody who relies on these templates or systems says to you, "Oh yeah, this is totally valid, and you should use it for all your investigations." I mean, is that a wise idea? I mean, is there something that fits all?
No, I mean, I wouldn't do that any more than I would use LegalZoom to draft non-compete agreements or anything else.
Yeah.
Right? Like, you need to be conscientious. I think if there's always a lot of takeaways from this, but one of those takeaways is, there's no such thing as one size fits all here in any of this aspect of the investigation. You want to have standard practices to a point for documentation, for anti-retaliation, for just generally responding to investigations, but not at the expense of thinking through what you're actually dealing with and fitting a problem to the solution you have. Not everything you can't fit a square peg in a round hole. So you just, some investigators, like I know there are mutual contacts that Helen and I have who are very good independent investigators who can do it in different settings. You know who we're talking about. And that person's outstanding, I think, in part because they've worked in a corporate setting. They've worked for the EEOC, for example, as well, and know different tacks and methods for going at it. But anybody who says, oh, this is my standard ABC and this is the only thing I do, you should always be wary of somebody like that.
My thought
Thanks,
on this
Matt.
stuff is you get what you pay for. So if it's like a flat fee packet of stuff, there's a reason for that.
Right. Now, with that said, and I do know the person with whom you're speaking, and I've actually referred business clients to that individual too, and that person does a phenomenal job. I have had situations with business clients where it's a really, really small business. I could tell from what the individual told me that it's something really petty. And I will give my clients steps on how to conduct an investigation, because I think it is really that simple. And I'll walk them through the process, and I won't even, get involved other than walking through what they need to do in terms of an investigation, what steps they take, and I'll write down like some instructions. There might be the same instructions as I might give someone else, because it is something just kind of simple. So maybe, some of the steps you take are simple, but you have to go with the flow and go where the evidence takes you and the information that you get. You have to be flexible, and you can't just follow a roadmap, because it deviates. There are forks in the road, as they say.
Well, with that said, we conclude the webinar. Great discussion, everybody. Outstanding. Thanks for your participation. Thanks to all the attendees out there for attending. look for Financial Poise webinars where, wherever better education webinars are sold. And we'll see you for our 6th and penultimate webinar. It's so hard to say goodbye, minimizing risk when terminating employees. That's on June 27th, also at 2 p.m. Central Standard Time. Look forward to seeing you all then, and take care, everybody. Have a great Memorial Day.
I'll set my
Bye, everyone.
TiVo. Thanks, Chuck. Thanks.